Hi, glad you could join us today as we deal with dispute resolution. I'm Jim Doyle from Doyles Construction Lawyers, here to talk you today through the various methods we have for resolving disputes in the construction industry. It's an important aspect that will affect every professional in the industry, and if we get a good understanding of the options available to us, we should be able to sort out all but the most difficult disputes. If we look at the industry context that we have in respect of construction industry, it's high risk. There are high commercial risks, high safety risks, high organisational risks in terms of interfacing between multi-party environments, all who are working on multi-projects, and somehow it comes together. So it's important to understand that you're in an industry and in a situation which isn't smooth sailing. You're not operating in a jam factory, and you've got to be on your measure to make sure you contribute to a safe environment, both physically, emotionally, and, of course, commercially. And the disputes that are common in the construction industry are over scope. The scope is always an issue. The interfacing between one participant and another is a source of potential conflict and confusion. And over time, everybody wants their job done before they can expect it. Everybody doesn't want delays, and every delay in the construction industry effectively delays a number of other people. If you cancel your brickie today, then he might only have a day's worth of work, but he might be tied up for the next 3 weeks, and you have 3 weeks delay out of a single day's stoppage. So you've got to be on your game. The other aspect is about payment. Payment is important because it solves many problems. If you pay extra, you can get things done better, faster, higher and stronger. If you don't pay, then of course the opposite usually follows. So it's important that you can understand the sources of disputes that are coming your way and what you can do to minimise them and then resolve them. The other aspect about disputes is that in the end, the courts will resolve any dispute that exists between the citizens of the country. But the resolution by court process to the full extent of it is a luxury that's reserved for those who are well endowed with common riches. So if you're in the situation of Kerry Packer, you can probably exhaust all your options in court. And if you're Mr. Palmer, you can probably go to court and have lots of litigation. But for most people, common sense and an ability to manage your disputes is an essential characteristic of survival in the industry. So today we want to identify the causes which we've discussed about. We want to discuss some best contract administration procedures that will reduce the risk of disputes. And we want to understand the resolution mechanisms and the way that they will operate so as to give us some sort of opportunity to resolve the problems before they get too bad. The other aspect is that throughout the course of time in the industry, you're going to have to continually strengthen your negotiation skills and abilities and mediation skills and ability, where you can bring parties together, seek common ground, and resolve disputes. So if we then look to the current industry sort of data and get a bit of an approach of the size of the problem we're dealing with, you'll see that there's a significant percentage and a significant cost in exploring disputes and not resolving them quickly. The other aspect is that it's pretty easy to understand that an early settlement is very often a good settlement. That is, if you settle it up quick and fast, even if you don't get the best deal you might have been able to achieve, it's usually going to work out better for you and better for the other party in the long run. Additionally, early settlements allow you to retain as much as you can of the cooperation from the other party and hopefully achieve a successful project completion. So we put some figures up here in the slide which show that there's sort of perhaps of the 248 billion of sort of government contracts, you might find 6-odd billion in dispute. On the one hand, it's a significant number. On the one hand, it's a significant investment in everybody trying to sort out those disputes. On the other hand, looking at things optimistically, it's not a bad result for that sort of volume of work. So it's important to realise that even if the industry is operating properly and operating confidently, then it will still have some problems. The other aspect to remember is that you don't have problems when you're a member of the mafia. You're either a member or you're not. All members are in good steads and all members get along well because the system is not one of integrity. It's not where people are legitimately trying to promote their own interest and see that their contracts are being discharged on a proper basis and then taking their disputes to somebody independent to resolve them. So you can expect that if there's too little disputes in the industry, things are not all as they should be, and that you should expect that there will be some disputes and some differences on projects, and you should expect that professional people can get together, look at the problems, look at the facts, and come to a resolution. And unless they do, there's some fairly substantial financial figures that will otherwise hurt everyone. So I want to look at contract administration, because if contract administration runs cooperatively and sensibly and hopefully profitably to all, life runs a lot smoother. So it's important to sort of translate. In the first thing, the purpose of the contract administration is to translate contractual obligations into day-to-day actions, to make sure that what you're asking someone to do is done, is clear, is done regularly and done well. It's important to convert things into what you need on a practical day-to-day basis. And that's demonstrated by safety, in the sense of if you want people to be safe, you've got to make sure that they carry through with safe practices and safety reinforcements throughout. Again, if you're wanting people to keep their certifications up, to make sure their insurance is paid, it's best to make sure there's a regular monitor of that rather than letting it go for some months and then finding out you've got a big surprise. So it's important as well to make sure you monitor the time, the cost and the quality progressively, so that if you've got a concern over quality, it's stopped early, it's discussed early, and steps can be taken to improve the performance at the time where it's most cheapest. The other aspect is to define your objectives and the scope, to make sure that if somebody needs to do something, it's clearly identified for him, and the best way of him doing it is discussed and implemented. Again, leaving it vague and coming back in 3 months won't help. The other aspect is you've got to identify the stakeholders. There's quite a lot of science at sort of an academic level in deciding how you should rank your stakeholders, how you should identify the decision makers in the various organisations that contribute to a project, and then trying to make sure that each of those has the right amount of information and the right amount of monitoring is conducted, so that what becomes a minor departure from proper performance can be quickly rectified rather than it becoming a big issue. Additionally, you've got performance and risk monitoring. Again, it's important to make sure that you learn more from a near miss than a direct hit. You've got to be aware of what the risks are and appreciate an increased risk in order to cut off the problem. Communication protocols should be implemented and should be keeping people in a very informed and motivated way on sites. And you've got variations. There are always variations in the construction industry. They've got to be dealt with. They give rise to people having to negotiate scope, time, quality changes, and the circumstance is that if you employ good administration processes, then the situation is the problems should be better controlled. So it's important to have an overall view of why you're doing things and what you're doing to make sure that they proceed in a sensible way. The other aspect is we should look at a few of the cases that have come up where the courts have had to decide things that have come up between people. And one here is the Darlington Futures contract, where the situation was that the broker had carried out a bit of unauthorised trading and lost his shirt and wanted to recover it from the client that he'd carried out that trading for. They had a limitation liability clause in their contract, and they said, well, we're sorry, but we don't want to pay. And the circumstance, it went to the court, and the court decided, well, we'll interpret that clause against you in a tough way because the situation is you're wanting the benefit of it. And on that basis, they said, well, it didn't cover unauthorised trading, and therefore the loss fell on the broker. So it's important to see that somebody's malfeasance has resulted in a loss, and from that loss, the dispute has had to be resolved, and the courts have had to come in and try and get a just result. The situation is that the point of watching for limitation clauses and not having too many wide expectations for what protection they'll give you is important. The next case I wanted to deal with was the case of John Holland Construction and Canaver and Brown. And in this case, there was a dispute over a global or total cost claim. And the situation is, it's an interesting way of how people have found it necessary on occasion, and with not too much support from the courts, to say, look, I've had total costs on this job of $40 million, and the situation is that you've only paid me 20. Therefore, the difference must be the difficulty you've made my job out of the problems you presented. So rather than asking for a price for each particular variation or asking for a delay cost for every delay cost, the concept is they whack it all together and say all the cost run must be, say, the principal cost. The problem with that is that although it's technically possible, if you're able to prove you did have a cost overrun and there was no blame on your side at all, and therefore the whole of it could be attributed to the other party, it might survive. But those sorts of claims have run into difficulties with the courts because the court says, well, once we get an idea that there's other factors coming into your cost overrun, then you'll have to break it down and prove exactly what's going on. So it's an angle where on some occasions parties have been forced to adopt that sort of attitude simply because of the fact that there was no particular records and no particular analysis that could replicate the loss they suffered. So the situation is you then say, well, what dispute prevention could we adopt? And early intervention is the only answer to most of our problems. Is once you've got a dispute, you should strike early and strike hard. That is, get to the bottom of it quickly, resolve who's to fault and what's the sequence of events that have occurred, and then see if you can fix it quickly before the problem gets too embedded. The situation you've got to look for is early warning signs. So if you're on a project, you're pointed to a project early in the process, you should be able to anticipate the likely causes of problems on that job. You're able to say, well, if I'm doing a road job at the back of Burke, then it's likely I'll have difficulty with getting reliable sources of supply of aggregate for the road. It's likely I'm going to have big problems with wet weather if I'm delayed and pushed into the wet weather. It's likely that I'm going to have problems in getting labour to that site unless, I've offered fairly good incentives and unless there's been a proper sense of progress and motivation on the site to keep the labourers there. So by identifying some of the problems, you can be careful and ready for their situation. The other aspect is you've got to keep records. You've got to keep records to show how you're going particularly. It's important that you pick up whether or not your productivity is tapering off or whether or not the project is getting slower and slower, and from a principal's point of view that the contractor is just simply not achieving what was needed in order that you can address the situation. And the situation is that raising these issues professionally can often solve the problem for both parties. An example of that is that, say, for instance, it's noticed that the productivity in a tunnel project that comes to mind was getting slower and slower, and they used to send out teams out there to a remote site to see if they could push it along. And they imported a tough and rough sort of project manager from Scotland to see if he could accelerate productivity. But eventually, when they properly investigated, they found out that it was a particularly difficult rock situation, that the geotech was extreme, and therefore at least they could adopt proper mechanism and try and make a success of it as soon as possible. So it's important to step in early to get the best result. The other aspect is you want to be aware of the difference between contract admin when everyone's smiling and generally going in the right direction and simply needs to be assisted with their productivity, and dispute management when you do have an issue and you do have to take it by the horns and see if you can resolve it. And the core principles of dispute management is fairness. If you want to go and try and drive an unfair bargain, if you get away with it, good luck to you, but most times it'll come unstuck and to your disadvantage. Timeliness, not letting things delay, making sure that you're prompt in your response to the problem. The difficulty of extended management structures and long latency in decision-making is a concern. Transparency, that is, putting the facts on the table in front of everyone so that all can resolve it. And you're trying to protect the project overall as a concept for people to be aimed at, rather than just their particular position and where they might expect to make a quick quid to resolve it. The other benefit is proactivity. There's no point in ignoring a problem when it develops. You've got to be on top of it. You've got to take action, even if that doesn't appear to get a massive amount of cooperation from anyone. It's important that you take the grasp the nettle and see if you can get some sort of progress and resolution in it. The aspect with that then is we should look at the mechanisms that we've got. The circumstance is really you start off with a graduation, going up to eventually ending in court if you can't sort it any other way. But the first one is negotiation. That's direct discussion between the parties. And it's an option that should be investigated and should be structured. There's no point trying to sort of resolve things informally where nobody's done any investigation as to the facts, where nobody's developed any position that they have to advocate, and that everyone's simply confused or trying to stonewall. So the situation is the quickest and least costly option, should be investigated without particular note as to exactly who bears it at the moment. If there's an easy, cheap solution available, it should be looked at. The next one up is mediation or conciliation. Most of you will have been involved in a mediation where there's a third party neutral who's helping the parties discuss the problem, work through the problem, and see if they can get to a resolution. Now, the problem with mediation is that it's very good if it works, but it's got no guarantee of working. So, yes, it solves lots of problems. It should be advocated and practiced on many occasions, and it does produce good results compared to the other options. But if it doesn't work, if you can't get resolution that way, you've got to advance to something, a more determined model. And that is the next step up, is expert determination. Expert determination is where you go and hire an expert, usually by agreement or by appointment, and that expert investigates informally the whole problem, talks to both parties, collects documents and information, and then eventually writes up a decision. The situation is that on the one hand, it's a bit rough and ready. There's no established procedure necessarily. There's no established ambit to what he's doing or where he's going, other than in a very tightly drawn expert determination. But if it gets to a result quickly and expertly, people are prepared to accept it, and it resolves problems. Additionally, it is, from a proper perspective, greatly beneficial to taking the matter to any arbitration or court proceedings, which in reality could have been resolved by any sensible independent professional. So expert determination has got a lot of value in it, and it's got a lot of benefits in advocating to people to resolve problems. And usually, if you can get an expert, that is, who knows something about the problem involved, then he can come up with a solution that might not be pleasant to everyone, but it may well solve the problem. Additionally, it tries to keep the cost proportional to the problem. So if you've tied out with that and you haven't got that problem solved, then you'll have to go to something more permanent and final. And the next step up is arbitration. Arbitration is private. It's also by a person who's either nominated by a nominating authority or alternatively agreed by the party. And he conducts a trial, much in the way of a court trial with claims and defences and evidence, statements and experts and a hearing. And at the end of that, and that might go for 12 months, and the hearing might go for 10 days. And at the end of that, the arbitrator will produce an award and eventually allocate the costs of the arbitration as well. But arbitration is very beneficial because it is quick. It's not so much cheaper than court, but it is quick. And the circumstances generally, it gives the parties the confidence that they have somebody who's experienced in that field. So if you want a problem over the construction of a solar farm or a wind farm, then somebody who's had some exposure to that situation, both exposure to the contracts, exposure to the projects, exposure to the technology, it often gives parties the confidence to accept him as an arbitrator. The benefit of an arbitrator is that you also get usually a fair amount of allocation of time from the arbitrator to determine the problems. Whereas if you go to court, you should generally have to stand in line with everyone else, and that can mean that there'll be delays. And then, of course, as the ultimate, if you can't resolve it any other way, the courts will resolve it. They'll resolve it in a legal way, which doesn't often offer practical commercial solutions, but they will resolve it. And they do a good job in terms of investigating, analysing, strategising, and providing parties with high quality sort of representation and expertise. But at the end of the day, somebody's got to lose, somebody's got to win, and the situation is a final result will come out of it. So it's important that you've got an overall grasp of those resolution mechanisms, and you realise the benefits of resolving it the earlier you can and the lower in terms of formal processes that you can, in order to make sure that the costs are proportionate to the dispute. So if we run through mediation again, which is very important, and mediation should be promoted before disputes get to a better stage. That is, you get a neutral party who's able to make some comment, make some analysis, contribute some sort of perspective to a party, and often get a solution that does keep everyone happy, but massively cuts off a problem and gets the result that is at least acceptable to both parties. The benefit of mediation is in particular is it's a lot shorter than any other project. You can generally get, by the time you get organised, a mediation which might only go for a day, and if it's successful, achieves a resolution that is easy and quick. The benefit of mediation is it's fundamentally an agreement of the parties. The parties can resolve a dispute over $1 million in half an hour if they want. They split it one way or split it another. But $1 million dispute going to court might take a year and might take a 10-day trial. So the benefits of mediation when it progresses, when it's successful, is substantial. The other aspect with mediation is that you've got to look for your mediator, make sure he's competent, make sure he's on top of what he's going to do, and that he's got a record of appropriate sort of control the mediation and control the parties in it. You've got various styles in mediation, and you should look to your mediator to make sure that he's the sort of style that you'd like. The situation is often mediation, even if it doesn't succeed on the day of mediation, can often lead to discussions and to negotiation afterwards. So it's a step to be adopted. In terms of negotiation, then, you've got sort of a situation where, with negotiation, you should be on top of it. You should have looked at defining the process that you're going to negotiate with. There's no point in trying to negotiate with somebody who's not at sufficient seniority in the organisation that you're trying to get a resolution with. The situation is you should be looking at what content do you have to provide to negotiate. Yes, you can just ring him up on the phone and yell at him and see if that works. Well, it's possible it might. But alternatively, it should be that there is some sort of report prepared, some discussion prepared, some case got into some structured order, so that if you've got a good point under the contract, it's clearly defined and well argued for. If you've got good points, as a matter of fact, that people discuss things with you and the situation, the facts are on your side, then they should be collected and put forward. If you don't do that, you make a problem that could be resolved into one that's very difficult. So the situation is you want to look through some of the elements of negotiation. You want to look through what your option is if you can't resolve it, because that might make you either more or less willing to move to get a successful negotiation. And again, if you go into negotiation with any particular sort of commitment, you want to think about how to approach negotiation. What are you trying to do, and how are you trying to motivate the other party to a common ground? So are you going to be hard and competitive in negotiation? Sometimes it's appropriate. Sometimes you've got to be soft and accommodate and try and persuade people to it. because you're more dependent upon them perhaps, or because sensibly you think that will be best to achieve a result in the circumstance. And the other one is lots of times you've got to be principled. That is, you've got to say, look, I'm not prepared to pay this amount of money for this poor job. Forget the money. I'm not prepared to pay for rubbish, so I won't pay for it. So you better straighten up and come to the party. If you've got to take that position, it's best to clarify it for yourself, and it's best to make it persuasive so that it's some chance of getting to the result that you want. Now, if you look at some other disputes that have occurred over the years, and I want to look at them against the background of SOPA in construction, and we take for the example New South Wales, because that's been a fairly leading state in terms of SOPA over the last couple of decades. And it's important that you get a feeling for where SOPA is, because SOPA is a statutory scheme where basically you can put a progress claim in, expect an answer within 10 days, and if you don't like it, within another 10 days you can go and get fundamentally a independently appointed adjudicator to have a look at it. Now, the situation has done a lot to smarten up the industry over a long period, and it's still continuing to have that role. And you should be on a basis that you can articulate your claim and make sure that it's well presented in order that you can get a just result of it. So the circumstances in this scenario, Broden was the first of the cases that started off with the idea of saying there's some basic essential requirements for a valid determination, but if those basic and essential requirements are there, the court will support it and enforce it. And the benefit of SOPA is that you can get a judgment in 2 months from when you start, whereas in a court process, you'd be better off to allow a couple of years. So there's a big difference. But that means that there's only limited claims you can bring. You can't bring any number of claims as you can in court. You can bring any claim you like. But in SOPA, you can only bring claims to the value of the work. You can't bring sort of damages claims, delay claims. There are restrictions around it. The next aspect was pro-build. And pro-build again was that it's excluding judicial review for non-jurisdictional error. And basically, when we boil it down, we can see that it's a situation where you don't get a review if the situation is it isn't a massive mess up by the adjudicator. So the adjudicator tries to do his job and he follows the rules fairly well. Then the courts are saying, no, pay now, argue later. That is, pay what he thinks is a fair price. You can always come back later to argue it if you want to go to court after it. And basically, that's meant that people have got to resolve their differences, and lots of times they accept results that aren't ideal, that they don't believe in, but at least the matter's finished. So again, continuing this situation, you'll see that there is Southern Hand with a matter that said, if you don't have a reference date, which is a particular date specified by the legislation, then you were not getting your adjudication upheld. But this is a trick question because the Parliament's been fairly receptive and they've taken out the need for reference dates in New South Wales. So that this method of resolution is a modern and efficient one because Parliament has from time to time changed it. They've also in New South Wales extended it to domestic construction. So if you're a builder and you're building for an owner and you do your job properly and you put in your claim under SOPA, then you've got an expectation that there'll be a judgment erupt from it. So it's a very beneficial sort of piece of legislation and something that you've got to see as a background when you're dealing with your mediations and negotiations on other fronts. The other aspect was the situation is facade treatment, engineering and Brookfield had a brawl. The situation is they said there that the company in liquidation, and the position is subtle now, but basically the issue was that there was some impediment if you were in liquidation to actually recover the provisional sum because you might not be around at the end to pay it back. And it's always a function of SOPA that the quick and easy determination is backed up with the prospect that you can later go to court and resolve exactly what it is that was the amount outstanding. So it's important to see that you're best off to get your claims in early and make sure your claims are paid on time, because if you go broke, you might have some trouble recovering. So I wanted to make sure that you'd been refreshed on SOPA and that you're looking at SOPA to make sure that you're doing proper claims and raising them early. There's no point in keeping your claims to the end of the job. That was the old system years ago, and it was bad for contractors and it was bad for principals, because principals used to stock up claims until the end of the job and everything was over and it settled down. Then they'd talk about the claims. It meant the claims were going on for years and years, whereas they should have been resolved quickly and led both parties to get back into the project and more productively remedy the situation and get on with their life. I had an example where an architect was adjudicating extension of time claims. Well, that's okay, but except when was he doing them? He was doing extensions of time claim that had been made during the job about 6 months after practical completion. Well, it lost all the benefit. There was no benefit for the contractor to get an extension of time at that stage, and yet the architect was slowly going through it at that stage. It's not sensible. It doesn't promote good projects and it doesn't promote efficiency and effectiveness to have lots of delay. SOPA has clarified a lot of that and cleared out a lot of the delay, but you need to be carefully vigilant and also well advised to make sure that your SOPA claims are kept in the order that they're of benefit to you. The situation is that looking at formal resolutions again, you've got expert resolution and their legal principles applied to ensure that the situation is that the expert determination will be of some effect and will be enforceable. You don't want an expert to come up with a decision that's in your favour and then find it's not enforceable. In this case of Glenville Projects versus North Melbourne Proprietary Limited, the situation is they had an argument as to whether or not they'd be bound by the expert report. And the court sort of came up and said, that it won't interfere with an expert's determination unless the expert exceeded the contractual mandate. So he was asked to decide bricklaying disputes and he went on to describe roofing disputes or something, or that he had not complied with the contracted process. So say, for instance, in your expert determination clause, you provided that the expert should talk to both parties, but then he could talk to somebody else as well. And in fact, he went and talked to someone completely different. So the situation is he's got to follow the process, otherwise he'll be upset. And it doesn't demonstrate a manifest error. So say, for instance, he investigated something, it's obvious that an award of a certain amount will be made in a party, and for some unknown reason, he decides to come up with a completely different situation. Then the court will upset it. But it's important to understand that when you prescribe a process for the expert to carry out, it should be carefully constructed in order then that all parties can be confident that when he follows that recipe, he should come out with a cake worth eating. The other aspect of the situation is formal resolution. You've got arbitration. And arbitration was and is a popular resort remedy for disputes and a situation where the courts will promote it. The courts are more and more attractive these days to, if you have an arbitration clause in your contract, which is properly drawn, then the courts will require you to go to arbitration rather than to come to court. In this case, at Cheshire Contractors, etc., they had a problem with a roadworks contract, and the situation is one party commenced court proceedings and said, we want to sue you in court. The other one sought a stay and a referral to arbitration. And the situation is that the court was required to choose between those two options. And the scenario is that given that there was a dispute that came within the arbitration clause with close and a consequential connection with the contract, then the court would stay and stop its own proceedings in favour of arbitration. So if the parties have agreed to arbitration, they've bound themselves to arbitration, and the courts will insist that they honour that bargain in the general sense. So in the normal course of event, the court will stay the arbitration, the court proceedings to allow the arbitration to continue. So when you're talking about litigation and court proceedings, it's worth to get a bit of an outline of what that means when you're involved in it. So you've got to understand that a court proceeding requires a very structured approach to the resolution of the dispute. So there's no informal negotiation sort of stuff. There's a formal process. Somebody must specify and to the standard required by the court, the causes of action required that he insists on, the facts that he's relying on, that he thinks he can prove, and he must go through the normal requirements of producing his evidence by way of statements of his lay witnesses or his ordinary witnesses, and then he's got to produce a report from his expert witnesses. And from the other side, there's got to be a defence, perhaps a counterclaim, and again, formal sworn evidence, formal expert reports. At the end of that, there might be a mediation that the court orders. There might be a conclave of experts where the experts are sent together to see if they can come to some common agreement or define the disagreements they have. And at the end of that, there's a trial. And the trial is not a fast process. It's a thorough process. It's good for murder trials. It's good for sort of royal commissions. But it isn't so attractive for a building dispute to spend 5 or 10 days listening to somebody's project manager go through his diary, in effect. So it's an expensive, but in the end, a pretty accurate sort of approach. The big aspect as well to you is that you'll need to choose the right formal process. If you're into a formal process, you want to spend some time thinking about it, because the reality is that, if you go to a court proceeding at the top of the range, you're going to be paying a fair sum per day for the benefits of your advisors assisting you resolve it. So it's worth sitting down and talking with the advisors and perhaps the other side and saying, well, what are the terms in our contract and what are the situation that we should adopt? And oftentimes it's possible to get agreement with the other side as to a way of resolving things, and that their agreement, thinking of one where a major arbitration in Adelaide, where there's some sensible agreement between the parties and their advisors to how this sort of dispute should be run, what the sort of timetable would be, and who would the arbitrator be, so that the parties could at least agree on that, and then start to try and debate the matter, but debate in a sensible and controlled way, and come up with a sensible result. So it's an important process. It's not a process to be particularly rushed, and it's a process to be got correct if you can, because it will save you a lot of hassle when you later proceed to resolution. Now, the situation is that there's some benefits, and I've put a slide here. I'll let you go through the detail of that in due course, but it's giving you some examples and some learnings that you can extract from some cases, that these cases are disputes that have occurred, that people have fought over, that people have spent quite a lot of money debating, and then you'll see usually the result is that one party wins or one party loses. Now, of course, that gives you a negative view of dispute resolution, and people sometimes say, well, I don't want to go to court because if I punch it out all the way to the High Court, I'll spend $1 million debating matters, and it might only be worth $1.5 million. But the reality of the court process is, and the courts support it by the various rules and arrangements that are in place, that people settle their disputes. That once you've had a careful review of it by both parties, that once they have put their evidence on and everyone's gone over what they can prove and what they can't and what's in difference, and then people have looked at the experts who've looked at the various technical requirements, and that information has been properly collected, then it is a greatly enhanced basis for negotiating a settlement. Generally, then you've got a series of advisors that can look at various aspects. You've got an engineer who comes in independently and looks at the engineering aspects and looks at who's responsible for this design problem, and then goes further back into it, analyses it, and comes up with an argument that can be seen to substantially win the day if it's pressed to its resolution. So the benefit of the court process is the pressure it puts on parties to defend their position or their claim, and if they can't, to see reason and settle it. So of approximately 100 cases going to court, you might only say 5% of them would go to a full trial. And again, in those full trials, there's a lot of pressure these days on trying to make those trials as quick and efficient as they can be. So you then come to a situation of dispute habits. If you want to prevent them, is read the contract early, make sure your responsibilities and your rights are clear, confirm everything in writing, because the benefit of sorting things out, if you've got the written information, is easier. Keep daily records. There's no point in having records that are intermittent or have big gaps in them. Issue timely notices. So make sure that you're telling the other party formally what's going wrong if it is going wrong. Track your progress and delays. The situation is if a project's on time and it's going as people have planned it, then it's likely that everybody is making some money out of it, in which case there's a great benefit that it'll keep going in the right direction. But if that starts to falter, then attempts should be made to resolve it, because the reality of it is that parties in a construction contract are really partners. They're bound together by their contracts and by the amount of money they're spending and the progress and work they're doing, and that unless they're able to say, well, everybody makes a quid out of it, usually there's a great chance of no one making a quid out of it. The idea if something's working effectively and efficiently is very important. The situation is issue, regular coordination meetings, make sure that people are involved in what they're doing and that they're able to interrelate to seek accommodation or adjustment in order that they can get their job done or otherwise respond to the problems they're having. So it's important that you adopt those procedures as part of your modus operandi. The other aspect about it is that you've got to adopt these days, in our new and enlightened times we live in, some sort of basic application of the principles that society is expecting for us to respect our other citizens, so that you're well advised, again, to seek some common ground with the people you work with, to exude some tolerance to their particular aspects or aspirations and their way of going about it, and to try and sort of ensure that everybody's well motivated to achieve the best result. It's important to adopt a personal style and a communication style that promotes that prospect. The situation then is that if you need to seek legal guidance on the thing, if the dispute gets out of the normal run of events, then what you should do is to get some guidance. One, you should get some guidance from technical people on technical matters and architectural and architectural, etc. But sometimes you can get the wrong guidance from people that are not experienced in resolving disputes. One example comes to mind that a principal was fed up with his contractor. He is annoyed with his contractor. He thought his contractor was ripping him off. So then he thought, well, what about the project manager? Well, he looked at the project manager and he wasn't happy with them at all. So he wasn't happy with the project manager or the contractor. So he thought they were both ripping him off. So then he decides, well, what about if the situation is that I get a completely new project manager and terminate the builder and start all again? Well, that was the decision made. But when one looked at it in the cold light of day, one could see that perhaps those decisions hadn't been made properly. The new project manager coming in was young and enthusiastic, but he didn't have a lot of experience in the area. And the situation is the early termination of people just because you think they're ripping you off might not be the most soundest decision. So some wise structuring early on in a dispute with some proper strategy and a proper approach to it, rather than just feeling that you're terribly much of a victim in the situation, you've got to get rid of everyone and start again, would have been a better option. The circumstance is you've got to look at your own strengths and weaknesses at the time that there's an issue, and you've got to have some fairly sensible guidance and sensible decisions taken. Otherwise, you'll get more problems than you deserve. So the situation is that the issue is, you might do some sort of contract health check, and you should do it from, every 3 months. Just have a look at your major contracts and run around quickly to see what aspects are there that would see that your projects are on the right move. The situation is these days is that oftentimes the people are actually on the site running the projects are fairly young, ambitious, and haven't had the benefit and would get the benefit from more experienced people coming in and having a look at them and having a shot at sorting problems before they develop. On the other hand, there's probably some projects which are controlled by more mature contributors to the industry, which might also need to be looked at as well. The idea of the 360-degree review of your projects every so often is often likely to, one, avoid disputes, but more particularly lead to a more productive and efficient method of operation. So disputes then, if we come back to summarise, they're disputes that will always be with us. Disputes perform a healthy value of making sure that everyone looks at what their performance is like and make sure that if their performance isn't satisfactory, that somebody else brings them up to the mark. And that's a healthy process in society to make sure that the construction industry delivers to society the appropriate proficiency and informers. But it requires discipline, it requires application, and requires hard work, which is the usual requirement in the industry. They're the comments that I wanted to make on this dispute section generally. The idea that you see it as a occupational hazard, or you see it as an occupational duty, and you see it as an occupational opportunity to lead projects to better results, to better protect and promote your own interest and that of your shareholders, and that you do it in a way that is intelligent and informed and aware of some of the solutions that might be available to you or those that you are representing. I'm happy to take any questions you've got. If you shoot in an email, we'll certainly come back and give you a quiet response. So we're otherwise happy with that, and I'll draw the matter to a close. And thank you for your attendance, and I trust that the material has been of assistance to you as you work through your life resolving all the disputes the industry presents. Thank you very much.